Okay, everybody, good morning. Ladies and gentlemen, thank you for standing by and welcome to the Houston MBDA Virtual Lunchtime Legal Forum, Chaos and Opportunity, Liens and Real Estate Law in the Age of COVID. My name is Gabriela Zambrano and I'm the director of the Houston MBDA Business Center. This is our 5th year of offering a lunchtime legal forum. Today, during today's webinar, attendees will be in listen-only mode. There will be a Q&A session at the end of today's call. My colleague, Mark Craig, is going to monitor the Q&As. If you have any questions during the presentation, you may submit it online by entering in the Q&A panel. As a reminder, this presentation is being recorded. Now, I'd like to introduce my colleagues, Mark Craig and Deidre Sutton, business advisors, and our office manager, Jessica Vasquez. Our next MBDA event is a virtual substance sandwich with Jay Dunn. It will be held on Wednesday, June 24, 2020, beginning at 11:30 a.m. We will have the opportunity to interact with J.E. Dunn and learn about upcoming construction opportunities with them. Today, we have the pleasure to meet with two senior counsels from Andrew Myers, Jack Turano and Bret Rycroft. Jack is an expert in commercial real estate, corporate and commercial transactions, and Bret is an expert in construction litigation and commercial real estate. Ladies and gentlemen, please welcome Jack Turano and Bret Rycroft. I think Bret is going to go first, right?
Yes, ma'am. Thank you. Thank you for the introduction as well. Good morning, everybody. Jack and I wanted to start off by thanking everyone for the opportunity to give this presentation to the group. We're both obviously with the law firm of Andrews Myers. We're a 50 attorney firm with offices in both Houston and Austin, Texas. Our firm handles all types of civil cases across the state of Texas. Our main practice areas are construction, commercial real estate, corporate law, energy law, employment law, bankruptcy law, as well as litigation and arbitration. Therefore, if you or your company have a question on one of these practice areas outside of today's presentation, please feel free to reach out to either one of us and we'll be happy to get you in touch with the right person. As you can see, our presentation is titled Chaos and Opportunity, Liens and Real Estate Law in the Age of COVID. We're going to give a general overview about some real estate issues that we've observed in relation to the COVID-19 virus, as well as general guidelines on how to perfect your lien claims in Texas to ensure you're collecting all of your funds with your customers. As Gabriela mentioned, we're both senior counsel with Andrews Myers. My main focus is real estate and construction litigation, while Jack Turano's expertise is commercial real estate as a commercial real estate transactional attorney. And as seen on the slide, our contact information is provided below. We're happy to respond to questions or assist with any legal matters. Since we only have about 20 minutes, this is going to be a general overview of these topics, and the purpose of the presentation is to give you some practical tips in order to assist your companies with potential issues that may arise. And it's my understanding there'll be a Q&A at the end of the presentation. Therefore, I'm going to turn it over to Jack Turano, who's going to discuss real estate law issues in the age of COVID.
Hey guys, thanks for having me. My name is Jack Turano. I focus on real estate transactions and corporate transactions at Andrews Myers, and I'm going to be speaking today to highlight some of the ways that COVID-19 has impacted our real estate deals over the last few months. Specifically going to discuss purchase and sale agreements, and I'll also briefly touch on lease transactions. Starting off with the due diligence. As you probably know, most real estate transactions over the last few months were either terminated or extended further into the year. The extent that COVID-19 in March was kind of unknown, but as offices and cities began to close, the ability to obtain essential services made it difficult to conduct due diligence. One of the key takeaways here on the slide is to make sure you have enough time to complete your process of due diligence, and that you have your team ready to go, and that you keep in touch with personnel the entire time as soon as you're ready to go into a new deal. Some of the disruptions that we saw were government office closures, travel restrictions, longer inspection times. It was difficult to get in touch with cities and counties for zoning and permitting purposes. You should really take into consideration possibly negotiating extensions for additional earnest money, also extensions based on the occurrence of certain events, whether there's a stay-at-home order or additional closures, or if you're not able to obtain certain information from the seller during the deal. You just want to give yourself some more time. Next slide. Due to office closures and personnel being at home, it was difficult to obtain surveys. You should make sure that you're keeping in touch with your surveyor and you're aware of any delays. Make sure you have your surveyor lined up prior to your entering into your deal. You also want to make sure, as far as title documents go, that you're in touch with your title company. A lot of title companies were working from home. Correspondence with the title company became a little bit more difficult. There was some lag time that you typically don't see. Title companies had difficulty obtaining some additional supplemental documents. One of the items that you want to make sure of in your contract is that the title period does not commence until you receive your title commitment and all the title documents from the title company. Next slide. Buyers should focus on expanding typical operating covenants. These are things that the seller is required to do during the pendency of the transaction. You want to address certain code-related issues. For example, the seller does not voluntarily close the office or the building while the contract is ongoing. That could potentially support a claim for a tenant rent abatement. You want to make sure that the seller provides you notice of any tenants who have employees that become infected. You want to make sure that the seller engages a hygienist in the event there is an outbreak, that they perform a deep cleaning for CDC guidelines. You also want to make sure that you're aware of any tenants who are asserting lease offenses based on COVID-19 matters. Slide. Force majeure. I know we beat this topic to death. We've had several presentations on this already, so I won't go too in depth about it. But one of the items that you want to know is that if your purchase and sale agreement does have a force majeure contract, and it does have specific COVID-19 related terms included. So you want to have things like COVID-19, quarantine, epidemic, pandemic included in that laundry list of items for the force majeure provision. You also want to look at your notice provision. You want to make sure that email delivery is sufficient, that you don't have to follow up with traditional mail. It's very important in the event that post offices are closed, that you don't have personnel that wants to go out and do their own. Next slide. Closing conditions. Purchase and sale agreement typically includes closing conditions that, if not met, excuse a party's performance. Parties will want to carefully draft special closing conditions that reflect COVID-related issues that must be met at closing. One of those is you want to make sure if you have multi-tenant property, that there's a cap for rent relief. If there's a single tenant property, you want to make sure you have some sort of consent control over any lease modifications or rent payments. You may also ask that there's a condition for no government orders or close downs that could affect your ability to use or operate the property. And also you want to make sure that your title policy is going to give you title insurance over the entire period of time from closing, from the commencement of your ownership. What we saw was that once county recorder's offices closed down, you couldn't record your conveyance document at closing. So some title companies were insuring over that gap period. You also want to look at title companies that may include an exception for that gap period to provide them with some coverage. In the event that they can access all the documents and record electronically, you should make sure this exception is removed from your policy. On leasing, I want to hit a few topics. Commencement date. If your commencement date tied to you opening for business or completing tenant build out, you want to make sure that you negotiate some sort of leeway in the event that COVID creates a barrier for you to open. Rent payment. We've seen a lot of tenants requesting relief for paying rent. Most leases do not provide the tenant to get out of paying rent as a result of COVID. Keeping that in mind, if you're a tenant, maybe negotiate a provision in your lease that provides you with an extension right or some sort of rent relief if you're unable to operate and you still have to pay rent. We also want to look at the common area maintenance provision in the lease, the CAM charges, and make sure that in the event that the landlord has to pass through expensive closing costs, or certain cleaning costs to you, that you're aware of those costs and that there's some sort of cap on them. Recapture rights, this is important to note. In the event that you can't conduct business in your space, if there's a recapture provision, the landlord may be able to kick you out and terminate your lease. You want to make sure that you're flexible on the SCODART provision in the event there's a mandatory shutdown. And with that, I'll give it back to Brett to talk about liens.
Thank you, Gabriella. So my part of the presentation is all about helping your businesses make your customers show me the money. Coronavirus is impacting construction jobs across the state of Texas, as well as the entire U.S. It's obvious that projects are being delayed, supplies are being pinched, people are getting sick in quarantine, and cities are issuing, obviously, stay-in-place orders. Therefore, contractors and suppliers are going to have to act quickly to protect themselves and their cash flow from the coronavirus fallout. And most importantly, this includes filing a mechanics lien as soon as possible. Therefore, my focus is going to be on mechanics and material liens in Texas. M&M liens are an effective collection tool in order to ensure that you get paid by your customers. And looking at what is an M&M lien. So they are security interests that attach to property's title. They're used to benefit those who have supplied labor or materials and those who have improved a property. So to kind of break that down, M&M lien attaches to real property, like those of you who have a mortgage on your house, like a mortgage lien, and it's got to be dealt with prior to the owner of the property being able to sell or transfer their interest in the property. Next slide, please. So the good thing about M&M liens is that they survive bankruptcy. They're a great collection tool for that reason. And unfortunately, during this coronavirus-fueled recession, it's likely that some construction projects will fail and some companies may file bankruptcy. So therefore, if an owner or general contractor files bankruptcy during the project, it's going to cause a financial ripple on everyone involved in the project. The good thing is that by recording an M&M lien, your interest will be secured because it is a security interest in the real property itself. Therefore, your claim with an M&M lien will have priority over those creditors who do not have a secured claim or whose claims are not tied to the owner's property. Next slide, please. As you can see, this is a wordy one, so I'm not going to go ahead and read it all, but under the Texas Property Code, there's 4 main categories of people who can file liens. So the first is those who provide labor, materials, or make specially fabricated items for a house building, improvement, or railroad. An example would be general contractor, subcontractor, supplier, or part manufacturer. Second are architects, engineers, or surveyors who've had a contract with the owner and who prepare a plat for construction, repairs, or improvements. I think this one's pretty self-explanatory. Third are persons who supply labor or materials for landscaping their project through a contract with the owner. And in my opinion, this category is underutilized. Landscape professionals and architects should use M&M liens to protect their interests, especially since some of these landscape jobs are costing in excess of thousands of dollars. Fourth and final category are people who supply labor or materials for the demolition of a structure. I think this one's important because M&M liens don't just protect those who are constructing and renovating, they also protect those who are demolishing structures. So if you don't think your business falls within one of these categories, feel free to reach out to Jack or I after the presentation, and we can discuss what, if any, lien rights your company may have. Next slide, please. So looking at what does a lien encumber, a lien attaches to the entire project. Let's say, for example, you own a pool construction company and just built this fancy pool shown in the photo. Your lien rights don't just attach to the pool area that you worked on. The important thing is they also attach to the land that the pool sits on. Therefore, you have a lien or claim against the mansion, as well as the land it sits on, not just the pool area where you did the work. Next slide, please. So looking at the procedure for filing an M&M lien, the first and most important step is to determine what kind of project are we dealing with. As you can see from the chart, it's important because different types of projects have different rules to abide by. based on this chart, you can see that public and private projects are governed by either certain provisions of the government code or the Texas property code. But the important thing to remember is that both residential and commercial private projects in Texas are controlled by the Texas property code for filing M&M liens. Therefore, in this presentation, we're going to focus mainly on lien rights for private commercial projects that hopefully will apply to most of your businesses. Next slide, please. So once we figured out what kind of project we're dealing with, we need to know kind of who's at the party. We need to know who is the GC, who are the subs, who are the suppliers, and maybe who are the bonding company if that's applicable. This is important mainly for making sure we get the property correct and to make sure that we send these parties notice of our claim. Next slide, please. So when you're thinking about filing this M&M lien, I always suggest making something simple like this diagram. To make it easy, you want to know essentially where does your company fall in this food chain with the project. For most work that you're dealing with a residential owner or a business owner directly, it's going to be a simple one. You're going to be the next ladder down. However, for more complicated construction projects, you could be looking at first, second, or third tier subcontractors or suppliers as shown in the chart. And these distinctions are important because it's possible that additional pre-lien notices are going to be required. Next slide, please. So the third step in the M&M process is to take the necessary actions to notify the parties of your claim and record the lien in the real property records where the property is located. So if you've done all that, you still haven't been paid, the next step is obviously to file a lawsuit. So looking back at what we've discussed so far, we've talked about what a lien is, what it attaches to, and what general information you need to have whenever basically have together before you record a lien. So next, we're going to talk about some of the deadlines for filing a lien as an original contractor. However, due to the time restriction, we're going to skip over some applicable deadlines for the next tiers down, the second or third tier subcontractors. But I'm happy to share that information with you after the presentation. And before I get into that, I want to briefly mention potential issues our clients have been experiencing with recording liens during the coronavirus. Next slide, please. So due to the pandemic, courthouses and governments are closed left and right. I think that's pretty apparent if you go outside. This is a big problem as it makes filing liens even harder. In some counties, you can record a lien electronically, but that's not always the case. For example, in April, I had a construction contractor trying to file a lien on a project in Ellis County, that's somewhere up near Dallas. And it's one of the few counties that does not accept electronic filings. The other tough part is, due to the pandemic, the district clerk in Ellis County was only open for a couple hours each day in the month of April. Therefore, we had to kind of rush, and I think it was the 13th or the 14th of the month, so right before the deadline, we had to hire a runner to go get our client's signature notarized and then hand deliver the lien affidavit to the courthouse during the short time they were open due to the pandemic. So looking back, my recommendation is going to be call the clerks in advance to make sure they're open and can accept your filings. If electronic filing is an option, call your attorney to assist you with recording the liens to kind of save you the time and money of having to go down there in person. Finally, be aware that getting someone to notarize the affidavit is also kind of a challenge. There's a lot of law offices, a lot of notaries are still not open to the public. So please try to plan ahead to either get the stuff filed in advance of the 15th day deadline or get in touch with an attorney to see if they're equipped to offer electronic notary services, which can allow you to basically get those affidavits notarized without being in front of them. Next, we're going to jump on, the next slide is talking about deadlines for liens. And as you can see, there's different deadlines depending on where your company falls on the ladder with respect to the owner. So focusing just on liens as an original contractor, you can see that there's only one step. You basically just need to file the lien. But looking at first and second tier subcontractors, there's additional pre-lien notices that have to be sent in order for them to preserve their rights, in order for them to make that claim valid. Next slide, please. So an original contractor is kind of obvious. It's a party who has a direct relationship with the owner. As an example, it could be a general contractor who's building a property, it could be a renovation company that's doing work for a residential homeowner, it could be a landscape company that's installing trees at a business or home, or basically any other business that has a direct relationship with the owner. So next slide, please. So if we're looking at this, the diagram again, obviously with respect to the owner, they're the next party down. However, if you or the general contractor ends up hiring other subcontractors or ends up buying materials from suppliers, those parties are depicted further down the ladder, and their obligations under the Texas Property Code are a little bit different before they were able to record the lien. Next slide, please. So when it comes all the way down to time to file a lien, at this point, you've probably completed all your work. You've exhausted all your options to get paid. You've made numerous phone calls. You've sent numerous demand letters. And the owner's kind of just blown you off. So at that point, you want to make sure that you preserve your rights and file the lien for the goods or services that you provided that have not been paid for. The big takeaway here is, or the big important date to remember, is that the lien affidavit for an original contractor has to be filed not later than the 15th day of the 4th month following the date in which the contract was either terminated, completed, settled, or abandoned. And I think if you look at them, most of those words are pretty easy to understand. The one word that always kind of raises a couple of issues is when is the project technically completed? So on the next slide, you'll see that fortunately the Texas Property Code, it does include a definition for when is work considered completed. The easy way to understand it is completion means actual completion of the work, including change orders. And I think it's broken down on the next slide. Because the definition basically allows you to extend your deadlines in which to file a lien for punch list work. However, as you can see here, warranty work does not extend the deadline to file the lien. So let's put this in an example. Let's say you own a roofing company. You install a brand new roof on a business in January. The owner refuses to pay you. And after several months, you think basically you missed your deadline. However, in June, let's say right after the pandemic is over, or basically slowing down, the owner asks you to come back out to the project for a few punch list items that are incomplete. You find out that your guys forgot to do work on the gutters on one side of the building. And since you haven't been paid, you're happily going back to the property. So you want to finish that punch list items since you just renewed your deadline in which you could file the lien. Now you can protect your rights. So putting this on an example on the next slide. This is a simple example of when does an original contractor have to file a lien. Let's say you own a renovation company. You do work on the project in January, which is essentially right before COVID-19 spread throughout the US. You've been trying to get the customer to pay. They've been ignoring your calls and deadlines. Since you have a direct relationship with the owner, you're not required to provide those pre-lien notices. Therefore, in this example, your deadline to file the lien is not later than the 15th day of the 4th month following the date the work is complete. So looking back at the example, we're looking at a deadline of May the 15th. The next slide is the second example. This is talking about punch lists, which I think is one of those important things to remember. You do some work for the owner in January and March. You think the project is over in March. You haven't been paid because of COVID-19 shutdowns. However, in June, the owner asks you to come back and do some punch list work. And looking back at that previous example, even though you haven't been paid since January, you happily send your guys back there to complete the work. And this is because your deadline to file the lien has been renewed. It's now October 15th, or 4 months after the project is complete. The next slide, we're going to talk about the 5-day rule, which is important in M&M liens. The big takeaway is that you must notify the owner within 5 days after the lien is recorded. The notice must be sent both via certified mail and registered mail to the owner and to all the other parties up the ladder. So if you're a subcontractor, you got to notify the GC as well as the owner, not later than 5 days after it's recorded. The bad thing is that if you miss that deadline, the lien is invalid and can be removed by the other party. So on the next slide, we're talking about, we've done all this stuff, and I know it's a lot of information, but the important thing you want to know is, how do I get paid by filing this lien? So at this point, you filed your lien properly. You've also sent the notice to the owner within the 5 days. So you're going to ask yourself, what do I do now? Most parties are going to end up paying you directly because they don't want the lien on the title. However, if you're dealing with an owner who's not concerned with the lien filing, we recommend sending one last demand letter to the owner, giving them essentially one last chance to pay your claim. If you've given them the notice and they basically blow you off one more time, at that point it's time to file suit to foreclose on the lien. A foreclosure is only valid through a court order by the judge. Therefore, the bad thing is that you have to have an attorney file a lawsuit against the owner. However, once you prevail in court, the judge can issue an order of sale to foreclose on the lien and sell the property to the highest bidder. So the big takeaway is you file this lien properly. If you file the lawsuit and win the foreclosure action, you can ultimately make the owner sell their piece of property, and you get paid from the proceeds of that sale. On the next slide, we're talking about, obviously it's, for most of y'all here, the last thing that companies want to do is to have to hire a lawyer to file a lawsuit. The good news is that in the Texas Property Code, the court is required to award attorney's fees and costs for a successful foreclosure action. Therefore, even though you may have to hire a lawyer to help you foreclose on the lien, the good thing is that you still may be able to recover the money that you spent on them. On the next slide, here's some just general thoughts and final thoughts about COVID-19 with respect to liens. So at this point, you've kind of heard our presentation, and you can probably think of a few customers that owe you money. I want to remind you that the time to file your liens now. As you know, there's certain deadlines when these liens have to be filed, and M&M liens are a fantastic tool to get you paid. I guess we expect that due to COVID-19, many contractors are not going to get paid on time, which is going to cause serious cash flow issues for their companies and for people further down the ladder. Therefore, it's likely that cash is going to be tight and payment deadlines will decline. So if you're thinking that you're going to experience slow or non-payment from your customers, make sure you preserve your lien rights. The last thing I want to mention is that once these stay-at-home orders are lifted, getting back to normal is not going to happen overnight. That's the hard part. You've got to be patient with getting your clients to pay again, and you want to make sure you properly calendar those deadlines to make sure you can secure your rights if necessary. And on the last slide, I guess Jack and I just wanted to thank you for the opportunity to discuss these matters with you. We hope this material is useful in growing your businesses and keeping more money in your pockets. And feel free to reach out to us if you have any questions, and we're going to turn this over to Mark for the Q&A.
So we have a question from our own Deidre Sutton. How can a subcontractor find out who the bond company that represents the project they are working on? Most subcontractors down the food chain report to a subcontractor above them and do not have access to the prime or the owner.
So the good thing is under the Texas Property Code, the owner is required to furnish that information to parties who request it. And if I'm not mistaken, I believe it's a 10-day deadline in which to respond. And the good thing with bonds is whenever someone bonds around a lien, they're required to notify the, obviously notify the owner that the bond has been filed, and you should obtain that information from the owner.
And Gabriella, this is a question for us. Is this being recorded? Are you able to send the slideshow?
Yes, we're going to send to those participants that registered for the course and requested that we could send them an email. So they will get their information either at the end of today or latest tomorrow morning, because it just want to make sure we have everybody. But actually, I do have a question from Mr. Carlos Nolasco, and he asked Jack, what kind of proof is required that you provided services, materials in order to file a lien?
So for Jack or for me, I guess you can throw Jack off a little bit by asking him a lien question.
I don't know why he asked Jack. I was like, wait, lien, that's you. But I wanted to make sure that I read the questions correctly. You know? Would
you mind repeating the question, Gabriela?
Sure. What kind of proof is required that you provided service materials in order to file a lien?
So essentially it's just an affidavit. So if you've completed work that's not been paid for by the owner, you're required to basically put that information, what services you provided, what goods were delivered to the project, in an affidavit and swear to it. And that's essentially all that's required. There's nothing further than that. The property code does mention that you can include your contract with the owner, but that's not required unless it's a residential project that you're filing a lien against.
Then we have another question from Tricia Lira. What about retainage? Can I lien on retainage? Will a bond company feel pressured to pay on retainage after completion?
So the quick and easy answer to that is yes, you can absolutely lien on retainage. There is additional notices that are required under the property code, but in respect, if an owner does file a bond to lien around the retainage, you do have a valid claim against that surety company to recover those monies.
And again, this is from Tricia. I was told by my prime that the owner, a city school, usually holds retainage through the warranty period.
So I think it would strictly depend on what are the terms of the contract. Normally, if it's done after the project is completed, there'll be some provisions saying when that money is required to be released. If it's gone past the contract period, then you want to make sure you get those lien notices filed in.
I have my own question. What if a subcontractor is worried about filing a lien for fear of offending the general contractor or damaging the relationship? What's your advice on that?
So that's a great question. Obviously, the liens are the last thing you want to do in a project, but the important thing to remember is that if you're the subcontractor working with a contractor that you have a business relationship with, you just have to be clear to them that you're doing this just to protect yourself. It's nothing personal. It's strictly business, and the way that the contractor fixes it is they timely pay you.
Did you have any more questions, Gabriella?
I'm trying to think. I thought the presentation was great. It was amazing. I really like the examples, that show. I really don't have any, so you mentioned that a lot of people miss the deadline. Is there another thing that small business owners fail to do when they come to you? Like, is there something you say, I wish they contact me and they tell me this sooner rather than later?
Yeah, so like relating it back to liens, obviously the biggest thing that people do is they miss the deadline, whether it's notifying us prior to those 4 months that have gone by. Other avenues that can be explored, but for liens, it's a very tight window. So if you miss it, you miss it. But we can still obviously file a lawsuit against them. It just may not entitle you to have a secured claim against their property. But there are other options out there.
Lesson learned is to contact us as soon as possible.
So I'm going to make a shameless plug. I'm going to make this a tradition. We're a federal program, the only federal program dedicated exclusively to minority-owned businesses. We're always looking for new clients. We happen to specialize in construction, but we're not limited to that. And we refer people to great service providers like Andrews Myers when they need a specialist. So, April Jones asked, this is to the attorneys, what is your success rates when lawsuits are filed?
With respect to liens or anything in particular?
Well, she didn't specify, so I don't know how to qualify that question.
I think we have a very high success rate. We've handled, as you can see from our practice areas, we handle all different types of cases. So there's roughly 30.
It was liens. It was liens specifically.
Liens are very high. So the main thing we got to do is we got to basically show that those materials or those services were provided, and which I think is a relatively easy burden to show. And if we do that, the judge will allow us to basically either foreclose on it, or the owner will typically try to settle the case out of court to make sure that we get paid to avoid the risk of foreclosure.
So
I have one question, Mark. Somebody wrote to me. Hold on a second. I have.
It's Holly.
Sorry, it just sometimes they write to me directly. So I have Glenn Lowenstein and says, can an environmental consultant file a lien for not receiving payment even though there's no material construction?
I've not dealt with that issue before, but it would depend on what the relationship is with the owner and what actual ties they have with the actual property itself. That would be one I'd have to research. That's a novel question for me.
Oh, we just got a shout out from Justina. She says, yes, great presentation. This is from Bruce Hawley. Is the pay when paid clause valid?
And yes, sir. The answer to that is it's a standard provision in construction contracts, and it is a valid provision in contracts. Obviously, the owner can't hold the money on forever, so there's other protections that guarantee your right to payment for contractors and subcontractors. A GC is entitled to basically withhold payment until they're paid from the owner, which is basically the money paid downhill.
If anyone has any real estate questions that they come up with after the presentations, feel free to give me a call or email me. I'm happy to talk to you.
Oh, I'm sorry, Jack. It's all about liens today, apparently. So we also got a shout out from Amanda. It says, great info. Thank you for the presentation. I gained a lot of valuable information.
Thanks, Amanda.
Any more questions you see there, Mark, on your
No,
side?
that's it. No, this has been a great presentation. A nice mix of high level and detail. So we appreciate you gentlemen very much. There's their contact information. And we'll be sending out this presentation to the attendees, and it will be posted on our YouTube channel. Is that correct?
That is correct. So we're going to see Jack and Brad in our YouTube channel with their picture together when they're speaking. So it's going to be nice. So I'm just letting you know. Do you see any more questions, Mark?
No, none from me.
Okay, well, everybody, Jack, Brad, thank you so much. I really appreciate it. This is great. I know that we have a lot of minority-owned business who are struggling during this time, and some of them who are thriving, but it's always good to learn about commercial real estate and liens. I know we have a lot of phone calls, so if you guys have people who were on the phone, if you want to reach out to MBDA at hccs.edu, we're more than welcome to share the PowerPoint and also to share Brett's and Jack's email. They've provided their email, their phone number. So even if you didn't get a chance to speak with them today, you can always reach out to them, and I'm sure they're more than willing to be helpful with their answer. And if not, they'll find out somebody within their own firm, because it's a big firm and they handle different topics as before. Again, thank you, everyone. Have a good lunch, and we'll see you in 2 weeks. Bye.
Thank you, guys.
Bye.